So, my name is Megan. I'm from the Aurora Public Library District, and today we are thrilled to welcome family law attorney Chris Lunardini, who is going to talk to us about what family law is and how you can make it work for you. We're running late, so Chris, let's go ahead and jump right in.
Okay, thank you very much, Megan. Good evening, everyone. As Megan said, my name is Chris Lunardini. I'm a partner at the law firm Sprados Davis. We're out of Lisle, and we have an office in Chicago. I'm a practicing attorney, been practicing for 20 years now. I grew up in the Chicagoland area, and I've been practicing in the suburbs for probably the last 14 years. I live in Aurora, and I've always practiced in litigation, and for the last 10 plus years, I've been practicing exclusively in family law. So I thought it would be helpful for the community to have some idea of what is involved in family law disputes, primarily divorce and child custody, visitation, and child support issues. I think a lot of those issues come up, and they're very scary for people to deal with. People don't know how to navigate the issues and don't know where to go and how to get their questions answered. And I think it's very helpful to give everyone a basic idea of what's involved, so that way you can feel more comfortable in dealing with either the navigation of the court and navigating the litigation on your own, or the questions and the issues you should be bringing to your attorney if you do get an attorney. First off, I'm going to go over with you some, through my PowerPoint here, I'm going to go over with you some basic items that often come up, initial questions that come up with regard to family law and divorce disputes. So some basic items to know and understand when you're going through a divorce or any child-related disputes. First big one is Illinois is a no-fault divorce state. So what does that mean? It means you don't have to prove that anybody did anything wrong, or you don't have to prove any grounds in order to get your divorce. All you have to show is that there are what I'm sure most of you have heard of are called irreconcilable differences. Basically that one person is unsatisfied with the marriage and they want to get a divorce. And that's all that needs to be shown to the court. It's a very, very low bar. The parties don't even have to agree. One party wants to get a divorce and the other one does not. That is perfectly fine, and the court will still grant it. Some other basic grounds for divorce, in case they come up, are irreconcilable differences, the first one. That's the no-fault ground for divorce. But two of the other more common ones that come up if these situations apply to you, one would be bigamy, or that's when you find out that your spouse was still married at the time that they married you. So if you find that out, that is a grounds for divorce, as well as what we call an annulment, or making the divorce void, or making the marriage void, I'm sorry. And bigamy is a way to get a divorce if you still have one spouse that is married. And the other issue is abandonment. That's another common grounds for divorce. It usually involves a situation where a person, one of the spouses has left the family, left the other spouse for a period of time. This one can be important and needs to be alleged sometimes because, for instance, if your spouse abandons you, you may not know where to locate your spouse. Well, serving the spouse is required to bring the court in and handle a divorce. If you allege abandonment, you don't have to necessarily serve the spouse, or it becomes easier to serve them. You can serve them through notification, through publication, and other means. So sometimes abandonment can be helpful, especially if you have a spouse who leaves the state, the country, and can't be located. The time frame is they have to have abandoned you for at least a year, and then you can prove up abandonment rather than going through even the no-fault divorce state. It makes it easier to prove grounds and approve and obtain service that way. Some of the other big basic questions and basic issues you should be aware of when you're going through divorce or child-related disputes is Illinois is not a community property state. What this means is that in Illinois, it's not assumed that all the property that you and your spouse have is automatically community property and marital property to be divided up 50-50. Rather, Illinois assumes that any property that you purchased or obtained or came into possession with after marriage is considered to be part of the marital estate or part of the property to be divided up as part of the divorce. There are still some states that do have community property situations, which means even if you came into the divorce with some property, once you were in the marriage with that, or once, I'm sorry, even if you came into the marriage with some property, once you file for divorce, all that property, even the property you came in with before you got married, is all assumed to be part of the marital estate. Here in Illinois, it's just the property that you obtained from the time that the marriage started up until the time the divorce is completed. Whether one spouse or the other spouse obtained it, it's usually assumed by the court to be part of the marital estate to be divided up. And you have to prove otherwise if you're going to try and claim that it was not part of the marital estate. The court can divide all assets and debts as part of divorce proceeding. That means whether you guys come to an agreement or not as how to divide up your assets and your debts, if you can't reach an agreement, the court can decide for you how all assets, that means money, that means houses, that means vehicles, that means any property of any significant value, retirement accounts, investment accounts, all of those things are fair game for the court to divide. And all the debts as well. That means all the mortgages, all the bills, all the debts regarding the support of the children, schooling debts. If you went to school, you went to college, you got advanced degrees while you were married, potentially those debts, even though they were incurred by one spouse who went to school, those debts are also open and available for the court to decide on to be divided up as part of the divorce. The court can set support and maintenance. So the court can set child support and maintenance for a spouse as part of the divorce proceedings. Even if you come to an agreement, it is important to know that the court gets to review child support and maintenance and does get to decide if it's reasonable and fair or not. And the court can decide that it's not. Now, if you reach an agreement, more times than not, the court will likely follow the agreement. But the court still has the ability to review, and if the agreement doesn't seem like it is fair and equitable to the court can override any agreement on child support and maintenance that might be entered into by the parties. The court can set and approve parenting rights and visitation schedules with regard to children. So as part of a divorce, or if the parents of the children were never married but are having a dispute on parenting rights and visitation schedules, the court does have the right to review any agreed upon schedule, and if a schedule can't be agreed upon, to set forth the visitation schedule and the parenting rights. And what do I mean by parenting rights? It's what we used to call custody, meaning the parent who has the majority of the time with the children, the house or the location that's going to be considered the primary residence of the children. And the court can also decide if the parents can work together to make decisions regarding things like medical treatment of the children, education, religion, and extracurricular activities, or if the parents can't work together, or one parent is much better suited to make the decisions, the court can award one parent the right to make those decisions. This is a question that comes up quite often with clients. Can the court in a divorce proceeding provide a religious annulment? No, the court cannot provide you a religious annulment. The court can give you a legal annulment. As I said before, an annulment is when the marriage is deemed by the court to be void, meaning it had never existed to begin with. But a court cannot provide a religious annulment. I do have clients who come in and they ask about getting the divorce, making it an annulment so that way they can get remarried under their religion. The court does not deal with the requirements and the appropriateness of a religious annulment. If you're looking for a religious annulment, you are going to have to go to your religious institution and to your pastor or your religious leader in order to get that done. The courts do not handle religious annulments. Now, a divorce or an annulment done legally might be part of what you used in your basis for arguing to your religious leader that you are entitled to an annulment, but the courts do not handle that aspect. The court does not look to punish spouses for bad behavior. And what I mean by that is The courts, especially in recent years, have been set up and the laws have been revised such that the courts want to make this a simpler procedure and a quicker procedure for most people. So the courts are not looking to look back at a person's marriage or both spouses' marriage and determine who was the good or the bad actor throughout the duration of the marriage. The courts will look for if there's bad behavior, quote unquote, by a spouse in and throughout the divorce litigation, and there might be ramifications for that. But anything that happened prior to the divorce being filed or prior to the child dispute matters being filed, the court is not typically looking to punish spouses for actions beforehand. I have a lot of clients who come in and they want to basically talk about all the things that went wrong in the relationship, or all the things that went wrong in the marriage, or all the things that went wrong in the parenting by the other spouse of the children. And I try to tell them in as nice way as possible, you should not get too worried about that, because unfortunately the court is not looking for that. And spouses who get, or parents or litigants who get too involved in those issues find themselves getting deeply involved in filing unnecessary litigation, unnecessary motions, and it usually ends up being a longer and more expensive process as a result. So what I try to tell my clients, my biggest tip for people when they're dealing with these issues is keep your eye on the ball, look at the light at the end of the tunnel, and just look for resolving the issues in front of you, how to get through the divorce or the child-related disputes, and get the matter through to the end so that an order can be entered by the court and you can move on to the next part, the next steps of your life, and not get bogged down in arguing over who is the bad actor in the relationship. Another point that comes up quite often and that people don't always realize is the court system is not equipped to manage everyday divorce or parenting issues. What does this mean? It means if you have issues with regards to who's dropping off or picking up the children from time to time, or whether this bill should be paid or that bill should be paid out of the marital estate, or day-to-day disputes and issues, the court is not the most well-equipped institution to manage these disputes. You should try your best to work them out between the two of you, between the two spouses or between the two parents, without having to go through court. Because again, if you have to file motions on these matters, it does not get resolved quickly. The court system is set up such that when you file a motion, the other side has an opportunity to respond, and then the court sets a date for everybody to argue and for their issues to be heard. This doesn't happen overnight. It takes time to get them resolved. And oftentimes, it may take weeks or a month or so to get some of these issues resolved. In which case, your dispute may have long been resolved, or you have now gotten long past the dispute, and now it's still in front of the court for the court to decide. It doesn't get done timely, and it ends up costing you more time and money than it may be worth oftentimes. So speak to your attorney about any of your daily disputes to find out if they're worth it to pursue in court and in litigation, or if there are other ways to handle the problems. And finally, one of the big things you should know when going into a divorce or child-related disputes, especially with divorce, is there a premarital agreement? And if there is, it should be brought up immediately. It should be brought up immediately between the parties. And if you get an attorney, it should be brought up immediately with the attorney. Premarital agreement may resolve a whole lot of the issues that come up during the divorce. What is a premarital agreement? Premarital agreement is oftentimes what we've called in the past a prenuptial agreement. It is an agreement that the parties may sign and enter into before they get married that spells out how they're going to divide everything up and how they're going to manage things if they do go through a divorce. In order for an agreement to be a proper prenuptial agreement, it has to be done before the parties are actually married. It needs to be in writing. The parties need to sign it, and there has to be proper witnessing of the documents. And it needs to be as specific as possible. There's no bright line rule as to what's considered an appropriate premarital agreement in Illinois and in a lot of other states. But I can tell you that if you are going to enter into a premarital agreement with your soon-to-be spouse, you want to make sure that it's as specific as possible, so that way the courts understand what your intention was, and parts of the agreement do not get thrown out or overturned should you file for divorce years later. I would say the best way to manage a premarital agreement is whether you're the drafter of the agreement or whether you're the person who's going to be signing it. Both of you should bring it to an attorney to make sure that it's reviewed and make sure that the attorney signs off on it. This eliminates any possibilities that somebody's going to argue down the line they didn't understand what the agreement meant, and also allows an attorney to look at it and tell you if there are things that can be tightened up or fixed in it. You don't need to necessarily pay an attorney an hourly rate for preparing a premarital agreement. If you have one put together with your soon-to-be spouse, a lot of attorneys will charge you a flat rate or a reduced rate to just review the agreement and give you their information and their input. And I would say take advantage of that opportunity. Try to find someone who'll do that for you, because it'll save you a lot of time and money down the line. Now, if you are going to be going through litigation involving divorce or involving child-related custody, visitation, parenting arrangement issues, there are some issues that require immediate attention and action, and you should not delay on these because it can affect what your rights are. And the first one is a big one: physical abuse of the spouse, children, or both. If that's occurring with regard to your situation, you definitely should call the police immediately. And you definitely should, whether you get an attorney to do it or whether you go into court yourself, you should go in and get an order of protection. You can do that, and often many of the courthouses have a simplified process if you handle it on your own versus having an attorney do it for you. But you should do it so that way you've got an order that you can use to enforce to keep the person who's causing the problems away from you or the children or both, if there are serious physical abuse problems. That order of protection granted initially is only going to be for a limited period of time, usually about 3 weeks. Then you're going to have to go back into court and you're going to have to prove why you should have it longer. So you want to make sure you keep track of those court dates and you appear in court so that it doesn't, your order of protection doesn't accidentally get thrown out because you weren't paying attention to the court dates. If you file for a divorce shortly after you file for an order of protection, oftentimes that order of protection gets rolled into the divorce and your divorce court judge can handle that as well. Another issue that comes up that requires immediate attention is if one of the spouses is removing all of the marital funds from the access of the other spouse. If that's happening and you're no longer able to have access to the marital funds, you need to file for your divorce immediately, and then you need to bring a motion to prevent that spouse from doing so. Because invariably, throughout the process, you're going to need access to those marital funds. And whether the spouse tells you, well, it's the money I made while I was working, or it's the money that I got from my retirement accounts, or whatever it may be, most likely that money is going to be marital money if it came into the marriage at some point over the course from the date of the marriage up to the date of divorce, which means no matter whose name it's in, both parties have a right to access those funds for purposes of the marriage and or for purposes of dealing with the divorce or the child-related issues that are occurring. So you need to bring up this to your attorney immediately, and you need to bring the matter before the court immediately. Spouse locks you out of the house. That's an issue that comes up often too. If you leave the house on your own, or your spouse throws you out of the house, they change the locks, they kick you out of the house, you can't get back in, you need to bring a motion immediately as well. So that way you can have an order entered by the court that says you're granted rights to use the property as well as the other person. Or even if the court doesn't grant you rights to use the property, at least the court will acknowledge your rights and say, okay, you cannot move back in, but nothing can be done with the house or the property inside the house until the divorce issues are resolved. So that way, no one can sell the house or get rid of the furniture or other property that's within and inside the house during the time that you've been locked out of the house. A parent or spouse is moving out of the state and is taking the children with. That's a big issue as well. Action needs to be taken with regard to that immediately, because if a parent or a spouse, if they're moving out of the state and they're planning to make it long-term or permanent, and they're taking the children with, that is not allowed under Illinois law unless there's express consent given by the other spouse or parent. And there's a procedure for getting that express consent in the statute or in the laws in Illinois. If a parent or spouse is moving out of the state, action needs to be taken immediately so the court can either prevent that spouse from moving out or that parent from moving out of state, or can make them come back if they have moved out. The reason it's such a big deal is if the parent or the spouse moves out of state, takes the children with, and they reside for an extended period of time in that other state, you may no longer be able to file in Illinois to have your child dispute issues handled in Illinois. The home state for those children may revert to the state where they've now moved to, which means you are now going to be fighting these issues in another state. A spouse refuses to pay child support. That's a big issue as well. And you can file an immediate motion for that as well. In order to get the child support, you need to take care of the children, even if it's during the divorce. If the parties are no longer living together, if one of the parties was the primary breadwinner and they cut off support to the children, you can file a motion, or your attorney can file a motion to get you at least temporary child support until a final figure can be figured out by the court, so that it can help you pay for the expenses and the bills related to supporting and raising the children. Another issue that requires immediate attention is if a spouse is using significant amounts of marital funds on non-marital expenses. They're spending the money, they're blowing the money gambling. They're blowing the money on items that are outside the typical marital expenses. They're buying brand new fancy sports cars. They're more often what happens is they're spending the money on somebody else that they're seeing now that they're going through a divorce. And it's not just a little bit of money, but it's a significant amount. It's a large amount of money. That becomes a problem. It's what we call dissipation of the marital estate. And a motion has to be filed immediately with regard to that, because that way the court is aware of what's going on, and the court can enter an order to tell that spouse to stop doing that. Now, the money may not be brought back into the marital estate immediately, but at least you put the court on notice and you put the other spouse on notice that this is inappropriate and it's improper and they should not be doing it. And at the end of the day, when the divorce is done, the court can take into consideration the amount of money that the spouse who is spending or dissipating the marital estate, the amount that they spent or dissipated, the court can take that into consideration when dividing up what remains of the marital estate between the two parties, and compensate or try to make the other party whole for one party blowing too much money, if you will. Finally, one of the other big issues that comes up that needs immediate attention or action is one spouse is attempting to sell the marital property, or typically it's the marital residence, or it might be a vacation home or some other marital property that is worth a lot of money. They may say, the house is in my name, or that vacation home is in my name. And they're going to try and sell it and take that money and put it in another account that's not in anyone's name that you can see, or try to take that money and put it elsewhere. You want to put the court on notice that that's going to occur. You want to bring in action immediately. Let your attorney know that it's happening immediately, so that way the attorney can file the proper motion and prevent the sale from occurring until either the court can figure out what's going on, or until the parties can come to an agreement on how the money is going to be split up. So those are the items that require probably the most immediate action if they come up in your circumstance. So now let's talk about some of the tips and considerations that you can use for making your divorce hopefully less contentious, and try to get it resolved sooner rather than later without having to spend too much time or too much money in attorney's fees. In what I do, I try to encourage as best I can the parties to come to a settlement on most of the issues in divorce. The reason being is because divorce can be a very emotional, long drawn out process, and it can also be very expensive. And at the end of the day, most of the parties, when everything's cleared and the air is cleared and the issues are resolved, most of the parties realize that they want to come out at the other side with enough money to kind of start things over and to move on with their life. They don't want to, as angry as they are with the other person involved in the divorce, they don't want to blow all their money fighting the case in court. So some of the things you can do to help you to prevent from making a long drawn out matter in court, and to help you save some money when going through the divorce process, when you're dealing with the financial issues of the divorce. First things you want to consider are Are there any safety issues? And do you need an order of protection, which we've already talked about? Do you need to move out of the house because of them? And if you do need to move out of the house, can you afford to do so? Are you able to move in with a friend, a family member? Are you going to be renting an apartment or renting someplace to live for a limited period of time while you go through the divorce? If you aren't able to afford it, do you need to bring a motion or have your attorney bring a motion to get that money from the other spouse? Or can you work that arrangement out with the other spouse? Oftentimes, if it's a hotly contested divorce, sometimes it can be worked out so that the parties aren't living under the same roof. Both spouses are willing to work out a budget so that they can move out, and one of the spouses can move out and they can try to eliminate some of the arguments and some of the fights that occur. One of the other considerations when you're going through the divorce: which of your issues are contested, which of them are uncontested? Note those, mark them off, talk with your spouse about them. Can you come to an agreement on some of your financial issues? So that way you don't have to either have the court resolve them or have the attorneys argue about them. Consult with an attorney early on. Even if you aren't going to hire an attorney, consult with an attorney to understand what are the costs, what are the options that the attorney can give you for representing you. And if it's an uncontested divorce, or if it's a mostly uncontested divorce, does that attorney offer some kind of a flat rate fee arrangement to handle the matters so that it doesn't cost you too much and it's not too expensive? I will tell you that my office offers a flat rate fee for uncontested divorces. So that way we can service individuals who are, for the most part, in agreement and need someone to go in to help finalize some of the issues, maybe negotiate some of the lesser issues, and put all the paperwork together to file with the court. Know your financial situation and be organized. What does that mean? It means get all your bank statements, get all your credit card statements, get all your retirement statements, get your mortgage statements, everything that indicates how much you make, how much you spend, put it together and be organized. Understand what your financial arrangement is. What is your budget? What is your budget going to be at the end of the day if you're just living off of your income and your spouse is going to be living off of his or her income? What does that mean for you? What can you afford? Are you going to have to sell the house or not? That's one of the biggest questions that comes up in divorces. Am I going to have to sell the house? Can you refinance the house and take the other spouse's name off of the mortgage and off the house? And can you afford it on your own? Or do you have to sell it and split the equity? Is the other spouse going to have to rather buy you out of the marital house? Understand your options. The best way to understand your options is to be informed and be organized. Typically in divorces, or typically in marriages, I should say, one spouse oftentimes is more in tune with the financial situation of the marriage than the other. If you're the one who is not typically in tune with the financial situation, take the time to get yourself in tune. Understand what your situation is. Next point, and it kind of stems off of the previous point of getting yourself organized, get at least 3 months worth of statements, pay stubs, assets, debts, business documents if you own your own business. Get all that together so you can give that to your attorney. Or if you guys are going to do it on your own, you can provide it to your spouse so that there is no dispute about what are the financials of the marriage. Put that together, get it organized, put it in a binder, keep copies of it, and have copies available to give your attorney and give your spouse. Fill out the attorney and court paperwork, including financial affidavits, honestly and with current information. And I'll add to that, also try to be timely in putting the paperwork together and getting it back to your attorney. There's going to be something if you go through the divorce process, or if you're filing for child support and visitation with regard to child's disputes, you're going to have to put together what's called a financial affidavit. It's a document that the courts typically require the parties to fill out, and it's a very detailed and organized document that has you fill in what are your bank accounts, what are your investment accounts, what are your retirement accounts, how much money is in each of them, what are the properties that you own, what are the vehicles that you own, do you have any life insurance policies, do you have any personal property of significant value, do you have any collections? All of those things are covered and more in the financial affidavit. It is very important that you be honest and upfront and current with all the information in the financial affidavit. Not only is it going to be helpful for your attorney, but it's going to be helpful for you and for the court when you're either trying to work out an agreement or if you have to actually go to trial on the matter. It allows you to get organized with all of your information. Take the time to fill it out. Don't fill it out willy-nilly. Don't fill it out with partial information. It's not helpful at the end of the day. You want to be as current and as informative and as honest in your assessment of the marital estate as possible. And you want to get it back to your attorney quickly. Most attorneys will give that document to you early on in the divorce process so you can start putting it together, and that way you have it and can provide it to the court and to the other attorney in the case early on and start working out these issues. After you file for divorce, keep records of your spending and payments on all the bills that are a part of the marital estate. So that way you know what you're spending, you can keep track of it, and if there's any dispute on where money is being spent after the divorce is filed, you can back up your statements that the money was spent on, for instance, the mortgage for the house, or expenses regarding the kids, or expenses regarding education and schooling for the kids. There are often times when, unfortunately, the parties become very emotional in divorce and accusations start getting made about who's spending money properly or improperly. You keep a record of your spending. You can offset those arguments very quickly, and you can point to the other side, this is where the money went, so you can head off any kind of litigation and motions in court. Control your spending during the litigation. Don't spend except for where you really need to maintain what they call the marital estate. In other words, spend it on the bills needed to keep the house going, to keep food on the table, to keep the utilities going, money that's needed to spend with regard to the kids' schooling, the children's education and extracurricular activities, but don't go spending over and above what you typically do. Don't go buying a new car. Don't go buying new televisions. Don't go buying items that you don't need yet. Keep your spending to a minimum during the divorce process so you can head off any arguments by the other side that you're, again, spending money inappropriately. This way, you can keep track of what you're doing. You know what money you have available to you. And at the end of the day, when the divorce is over, then you can spend on those items, those luxury items that you can afford once the divorce is done. Finally, consider your plan for division of the marital estate, division of the marital assets. Even if you're not on talking terms with your spouse or the parent of the child when you're looking at the issues regarding child support, talk with your attorney if you have one, or if you don't, put together your plan for how you think things should be divided up, for how the marital estate should be divided up, for how if it's dealing with child support issues, how child support should be divided up. Have a plan in your head as to how you think things should go. So at least you have a starting point when you start negotiating with the other side, how things should be divided up. Know your plan, have it available to you, bring it to your attorney, discuss it with your attorney so your attorney understands what is important to you and what's not. Here are some tips and considerations for child disputes, for those child-related issues that come up not only in divorce, but if you never got married and you're having child-related issues coming up between parents of a child. First off, again, are there safety issues? And do you need an order of protection? You need to get that immediately. That's something you need to act on right away. The sooner the better, because that way you can stem any future problems and you can show the court that there are issues with, as we talked about before, physical abuse that need to be managed by the court. Again, you should consult with an attorney. Whether you end up hiring an attorney or not, talk with an attorney about what your options are, what the anticipated costs would be, and whether there's payment plans that the attorney can offer you for representation. Prepare a plan for parenting time and discuss your plan with the spouse or with the parent of the child. So oftentimes one party has, or one parent has an idea of what parenting time should be, and the other parent has no idea or has their own idea, and they've never exchanged, the two parents have never exchanged their plans and their ideas. So they don't know if they're in dispute or not. They don't know where they overlap and where they can agree and where they don't. So have an idea of what you think the parenting time should look like. The visitation time. Should it be every other weekend and a couple of nights during the week? Should it be rotating weeks? Should it be extended weekends once a month plus every other weekend? What kind of arrangement would work for your schedule? What kind of arrangement would work for your spouse's or the other parent's schedule? Have a discussion and see if there's a meeting of the minds there. See if you guys can reach an agreement. And even if you can't, you have an idea then, what are the issues? What is your plan? And you have something you can propose to the court versus just going to the court and saying, Judge, just put into effect whatever schedule you think is appropriate. You don't want to do that because you never know where the judge is going to come from. You want to have a plan yourself. Be flexible. The court's going to expect you to be flexible because the court understands that children's schedules change over their lifetime. And they're going to expect you to be able to be flexible because the court does not want or does not expect that parents are going to be running back into court every time there's an adjustment in the children's schedule to work it out. And the courts don't appreciate when that happens. The court wants to see the parents be flexible and to be able to work out some of these issues themselves. Another tip and consideration: both spouses are going to have to take a co-parenting course, whether you're dealing with these issues in DuPage County, Will County, Kane County, Cook County. There's a co-parenting course that both spouses are going, or both parents are going to have to take at some point over the course of the litigation. Take it early. It's usually, most counties offer it as an online course. It takes some time to do. Take it early so you don't forget about it and you're scrambling to do it at the end. Another consideration for the parents: will both parents remain in the neighborhood? Or is one parent, for instance, going to be moving out of state, moving to a neighborhood that maybe is a half hour away, 45 minutes away? All of those issues are going to play in on what the parenting time is going to look like as a result. So figure out, where are both of you planning to live? If you're going to remain where you're living now, or if after the separation occurs, you're going to each be moving to different neighborhoods. Where the children are going to be going to school as a result. Discuss child support and division of the child expenses. You may not reach an agreement, but at least start discussing, what is your income? What is the other person's income? What do you expect from the way of child support and child expenses? Can you reach an agreement on some of these issues without having to go through a hearing in court? Not finally, but with regard to child support, if you're the parent seeking child support, file for child support as soon as possible. Even if you're able to reach an agreement, file as soon as possible, because once you file with the court and the court makes a determination of child support, the court can order child support be paid back to the date when the actual request for it was made. If you wait and you wait and you wait and you can't work out an issue, or you can't work out the issue of child support, and you wait 1, 2, 3 years, and then you finally file and ask the court to give you child support, the child support the court can award you is only from the time you file moving forward. So the 1 or 2 or 3 years you may have waited, you may be out of luck and may not be able to get child support for that time period. So get that on record as soon as possible. If you're looking to try and figure out what would be an estimate for calculated child support given your circumstances, the Illinois Department of Health and Family Services at this website here has a calculator on there. You can put in your information and it gives you an estimate. Now, there are other circumstances and other factors that are taken into consideration by the court when you ask for child support, but it'll at least give you an idea of what child support should be in your circumstance so you know what to expect. Gives you a starting point to work with. If you have disputes in your divorce or your child parenting, visitation, child support matters and litigation and issues, some ways of resolving the disputes short of going to trial are listed here as follows. First, start by discussing the issues with your spouse or with the parent if you aren't married, of the other parent of the children. No matter how uncomfortable it is, you should try to have a discussion. This way you can try to figure out, maybe you are able to reach a settlement on some of these issues. If not, maybe you're only going to be able to reach a settlement on just a couple of the issues. But at least you've made some headway and you don't need the court or the attorneys to work out all the issues for you, and it can save you some money and time. It also gives you an idea of where your spouse or the other parent is coming from, and you'll know whether or not it's going to be a big issue that's going to require a lot of fighting, shall we say, or if it's going to be a smaller issue that you might be able to work out with some help from the court or the attorneys. Consider mediation. Mediation is where you have an attorney or a trained mediator who presides over your discussions and helps you reach a settlement. The mediator doesn't impose his beliefs as to what's right or wrong on your discussions. He or she can't force you into settling, nor can he make you sign off on a settlement agreement. But the mediator can talk with you, can help you see some things that maybe you didn't realize would come into play if you have to go forward to court on the case, and may be able to help you reach a settlement. Mediators can oftentimes cost you less on an hourly basis than an attorney will. Mediator might be able to help you either before you get an attorney and before you file for divorce, or after you get an attorney and you filed, but you can't reach a settlement on some of the issues. Your attorney might be able to point you towards a good mediator that he or she has used before, and the mediator may help you reach an agreement. A four-way settlement conference. That's where the attorneys for each of the parties and the parties themselves get together in a conference room, or in this day and age, maybe on Zoom, and discuss out the issues and basically try to work in that mediation fashion between the four of them to reach an agreement. This oftentimes can help the parties reach an agreement on many of the issues, allows them to voice them. Some of the issues the other party may not have even realized they had, or what their concerns were. And when you voice them in this way through a settlement conference, the parties feel that their issues have been heard and they can work out an agreement as a result. Finally, short of going to trial, you can ask your attorney to set a settlement conference with the judge who's handling the case. And the judge, if the parties are both in agreement on it, the judge can have the parties take part in a settlement conference where the judge will give recommendations. And that's oftentimes very helpful too, because the judge is often the same judge that's going to be presiding over the divorce trial if the case goes to that. So the judge will usually give very reasonable and very helpful recommendations in order to avoid trial. And the attorneys usually know that the recommendations are good recommendations because they know the judge is likely going to follow those recommendations if the case does have to go to trial. So that can be very helpful in bringing the parties to a conclusion and to a settlement as well. The biggest caveat, and you'll notice the star here for the statement, know your issues and plans before you participate. So know what your issues are and what your plans are with regard to handling the disputes in your case before you take part in your discussions with your spouse, your mediation, your four-way settlement conference, or your settlement conference with the judge. It will help you invariably because now you know you have yourself organized, you have yourself well educated on what the problems are, and you know what you expect to get out of this situation. And you can talk in an educated manner about what you think the bills are that need to be covered. What do you think the child expenses are that need to be covered? And all those kinds of things. So know your issues, be well prepared. Don't just plan on your attorney being well prepared. Sit down with your attorney in advance of any of these conferences and discuss with your attorney as well what the issues are. And make sure you're on the same page so everyone knows what to talk about. So finally, when all that's said and done, you're going to finalize your divorce. You're going to enter the settlement documents with the court, and you're going to have what is called the prove up date. That's the final date you go in front of the judge. You present the judge with all the paperwork, and you present the judge with the financial settlement and with the schedules for parenting and decision-making with regard to the children. And the court will have that prove up. You'll be sworn in under oath. Both parties will be. And the attorneys and the court will ask you if you understood the agreement, you plan to be bound by it, and it will all be sworn testimony. And the court will review the agreement and make sure that it's a sound agreement and will hopefully, at the end of the day, authorize and approve the agreement and enter it and stamp it as a divorce or as a order for parenting time, parenting visitation, and resolution of the parenting issues, or both if they're both involved in your case. And I tell you that because a lot of parties don't realize that at the end of the day, when they come to an agreement, they're still going to have to go to court. They're still going to have to give testimony to the court, letting the court know that they understand the agreement so that the court can approve of the agreement, can stamp it, and can enter it as a final divorce agreement. So those are the typical issues that come up when you're dealing with divorce or child-related issues. Those are the typical processes for handling a divorce. Those are all the tips and considerations you should have if you're taking part in a divorce or child-related issues. Those hopefully are tips that'll help you understand the costs involved and how to keep them lower on your end, so that way you can move through it quickly and more efficiently. So with that, thank you for your time. Thank you for listening to the presentation. I hope you found it helpful and informative. And any additional information you need, you're welcome to contact me. Again, my name is Chris Lunardini. I'm with the law firm Speratos Davis. Our main office is in Lisle. We do also have an office in Chicago. You can contact me at my direct number at 630-434-0551, or at my email address that you see listed on the information on this page as well. Thank you very much for your time. I hope you found it helpful. And with that, good luck with your issues and have a good evening.
Thank you so much, Chris, for providing that information for us. And I will let you know, I do see that we have some people watching us on Facebook. And like I said, we do also have people who visit the recording after the fact. So if anyone does reach out to us at the library with questions, then I will get in touch with you as well.
Thank you. Thank you very much, Megan, for having me and for allowing me to put on this presentation.
Yeah, thank you for the information. I really appreciate it. All right, you have a good evening.
You too. Thank you.
Take care.
You too. Good night.